Hey, what's going on? This is Will from Fed Employees Fight EEO Abuses, our Facebook group. Hey, I just wanted to reach out to you for a minute and really think about some things. I'm working on my complainant's reconsideration of a request or appeal, and what this is basically mean I'm at the end of the road of my EEO complaint. I've submitted the complaint. The AJ's ruled against me. I submitted an appeal. AJ also ruled against me in that. So what are you left with after that point? So basically, my options are to quit, take it to circuit court, or or do a reconsideration. And reconsideration is not. You have to remember, reconsideration is not a reappeal, right? But it simply says that I am appealing to the Office of Federal Operations, asking them to review the appeal based on the grounds that appellate decision involved a clearly erroneous interpretation of material fact or law, and or the appellate decision will have a substantial impact on policies, practices, or operations of the agency. Now, I'm going to tell you something, guys. I'm pro se. And first of all, it's almost impossible to get through this process pro se without a lot of reading, without a lot of research, without a lot of education, self-education. The first and the easiest place to start, of course, is on the EEOC website. Look at all those court cases. And what will you do after that? Then you actually look up those court cases. But I'm going to tell you a golden gem of a tool that you must have. You must have a subscription to an online database tool that has all court cases filed almost in the whole entire America. If you don't have that, then it's really, it helps with studying the cases. You have to study each every one of these cases. You have to learn what this language means. You have to see how people lose. And a few times you'll see how people win. So here's a big problem I found by studying cases at this reconsideration phase. Reconsideration is clear. They say that it is not, they're clear. They tell you that it is not I'm kind of reading here as we go. It says the moving party of the court, the party moving the court to reconsider its decision carries the burden of proving that some harm would accompany a denial of a motion to reconsider. It's very important. In order for justice to require reconsideration, logically, it must be the case that some sort of injustice will result if reconsideration is refused. Remember that. That is, the movement must demonstrate that some harm, legal, or at least tangible, would flow from a denial of reconsideration. And it cites the court cases. Finally, even if appropriate legal standard does not indicate that reconsideration is warranted, the court may nevertheless elect to grant a motion for reconsideration if there are other good reasons for doing so. All right. So this is one of the things you have to really pay attention to when you do try to go for your reconsideration. You're not entitled to a reconsideration. It is not a reappeal. Appeal number 2, no. What you have to really prove is that there's a clearly erroneous interpretation of material fact or law in your appeal case, right? What do you mean by that? Sounds pretty simple. The problem is we always tend to re-adjudicate, and it's clear. The language is clear that you don't get a chance to re-adjudicate. I've read that in all the cases that got dumped. The commission said, hey, you don't get a shot to re-adjudicate your cases. So let's take, for instance, in my case, here's a simple example for me. I had an 18 claim complaint. Easy instance is that the AJ only neglected to rule on 8 of my claims. Of course, dumped my whole appeal, but didn't even mention, didn't cite, didn't quote, didn't reference didn't rule on 8 of the claims. The first time I filed the appeal, I said, hey, these matters were based on circumstantial evidence. The agency never presented evidence to validate their points, their claim. I said, hey, told her that I filed a motion for to have a real compliant and lawful investigation. I said it was non-compliant, it was shoddy, and it was biased. And I pointed out specifically what was omitted, what was left out. I did that already, right? So that was at the appeal. The appeal, they dunked me, lost me, act like I didn't say anything. Throughout, didn't pay attention to any of my evidence, any of my motions that I filed, that I put my own material facts in, didn't even factor any of those in. Well, why is that important? Because when you file for appeal, they're supposed to look at, they're required to reevaluate your case in novo. In novo is basically saying, hey, brand new eyes, regardless of what the last judge saw or ruled, we're bringing brand new eyes based on all the evidence in the file, right? So on that appeal, it turns out, guess what? Again, they didn't rule on the same 8 claims, failed to again rule on them, and failed to include all the undisputed material facts that was in my motions. So what's the problem? The problem is that often we will relitigate what we litigated the first time. And I'm telling you, it doesn't matter if you're absolutely right. If 10 out of 10 people would, outside of EEO say, hey, yeah, that's true. If you can get 20 judges, man, on TV and otherwise, say, yeah, that was true. And they still cheated you. We tend to, especially as pro se clients, we're emotional. We want to clarify and point out how we got cheated and how we were supposed to have done right. But that's not the point. What we're supposed to do, if you want to have a shot at justice, remote shot at justice, and that's all you get in this EEO stuff, is you want to prove how that AJ's decision involved a clearly erroneous interpretation of material fact or law. So what is my approach? Well, I want to immediately say, hey, well, I want to make sure I understand that language. I want to say, what is material fact? And the law says the commission's regulations allow an AJ to grant summary judgment when he or she finds there is no genuine issue of material fact. And it cites the CFR 29/1614.109G. An issue of material fact is genuine if the evidence is such that a reasonable fact finder could find in favor of the opposing part of the non-moving party. And it quotes the court case. A fact is material if it has the potential to affect the outcome of the case. In rendering this appellate decision, we must scrutinize the AJ's legal and factual conclusions and the AJ's final order adopting them. De novo, right? So what does that mean? In my case, I'm saying, hey, well, what did she do wrong? I listed a whole bunch of undisputed material facts, and they weren't evaluated. I have to make sure that when most of us pro se, and I've seen a lot of lawyers as well, there's a lot of losing. There's only like 98% loss rate. There's 2% victory rate in this stuff. So there's a lot of stuff going on. And I found there's a lot of cheating on the EEOC's part. But what happens is that, in this case, we would say, hey, I submitted my undisputed material facts. They weren't ruled or judged on, which may be true. But that is not what I need to argue at this stage. What I need to argue is that the AJ's decision involved a clearly erroneous interpretation of 29 CFR 1614.109G as evidence in CELO text versus Catrick, blah, 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 and cite the court cases. And then I explain by her making a ruling without access, factoring in, or weighing the evidence in the undisputed material facts that I also presented. My undisputed material facts disputed the agency's undisputed material facts. Therefore, there is a dispute in the material facts that must be weighed out. Law says if there's a dispute in material facts, I think that I just read it to you, then we can't get a summary judgment. Okay? So at this point, I say, hey, yeah, based on that, there's an injustice that will result. The injustice will be that the judge violated the laws as outlined in the CELO text versus Catrick's case by disallowing, ignoring, refusing, not acknowledging a dispute in material facts, and then I presented my own undisputed material facts. Got it? You understand the difference? We have to really understand or cite what law, what egregious or what erroneous interpretation. The erroneous interpretation was in CELO text and Catrick's. And then I give the example of how or what happened. And that's what I presented. Does that make sense? So again, a lot of us, we go back to, our points that we litigated the first time. And even if we were right, we were often cheated out of and denied. That's part of the game. Weeding people out, weeding us out of all the tens of thousands of complaints that's made. If they adhere to the law each time, companies and agencies, well, I'm with federal, so federal agencies have gone broke by now. So they need some help, and we have the appearance of adjudication process via the EEOC, but in all actuality, it has to be made incredibly difficult. But not only is it difficult, in this case, like I just explained to you and proved to the courts, that the judge didn't even regard my undisputed material facts. The judge did not rule on 8 of the 18 claims that I filed. So what I have to do is explain how her passing the ruling on the whole case while not ruling on these claims, how it was an erroneous interpretation of CELO text versus Catrick. All right. I hope I explained that. The takeaways are you have to study, you have to learn. Yes, most of the time you're right. You were done wrong. You were treated wrong. Yes, it's often hard to determine whether it was racial animus. But yes, even if it was racial animus, it's hard to prove it. But yes, even if you are close to proving it, quite often the AJs will throw your evidence right in the trash, just like you never ever presented it. All right. Bless you and good luck. I'm Will.